Could you add that to the list?
Council, do you have any other preferences to what motions you want to take a look at?
I don't, Judge.
Judge, I noticed that the people filed a response to our notice of invocation of Mr. Deere's rights, D002. That was a notice pleading. I don't have any additional argument on that. I understand their position. If those issues get raised in the future, we're going to have to address them. But we are asserting all of his rights and privileges.
Okay.
No, you're not.
It'd probably be easiest to go through them. We don't have that many at this point. D001 we've already dealt with. That's the pretrial publicity. D002, you don't need an order on that. That's in regard to invocation of rights. D003, the motion for preservation of physical evidence. I believe I dealt with that at the last hearing.
You did, Your Honor.
All right. D004, which is a notice of representation and demands for non-testimonial identification procedure. I don't believe I dealt with that one.
This is D004, Your Honor.
Yes, sir. Well, that's a notice one as well. But
Yes.
So we really don't need anything on that one. Do you agree with that?
I do, Judge, and we would agree that any Rule 16 orders or requests, you would hear about those, obviously, or any 41 ones, we will notify defense counsel prior to seeking any of that information.
That would be acceptable. We're also asking for notice that if the prosecution is pursuant to their argument in response to D002 is seeking to obtain any records of Mr. Deere's, either by SDT or by statute, that we've provided with some kind of notice of that so that we can lodge some objection if we see fit.
Any objections to that?
Judge, we will comply with the rules. The rules for the subpoena ducis tecum require immediate notice to defense. We will comply with that.
I take it that's a no objection?
Yes, sir.
Thank you. There's a motion for access and preservation of the crime scene. That's D005. I believe I dealt with that on November 30th as well.
I think you did, Your Honor.
Yeah, and that's the one I mentioned. The attorney for Planned Parenthood is here, and I believe we're going to meet. They want to meet with defense counsel. They have concerns of protecting certain privacy interests, their HIPAA interests of personnel and patients. So they would like to meet with them to talk about potentially coming back to the court with stipulations on how the crime scene viewing can be done so the defense can see it for their purposes.
Seal the truth, huh?
But also protect the
Kill the
privacy.
babies. That's what Planned Parenthood does.
Any objection to that procedure?
No, Judge, I do not. It's not our interest to violate any of the privacy concerns of patients or doctors at Planned Parenthood. Certainly not. We're very concerned about that, and we're willing to do whatever we can to preserve those issues. That being said, there's no reason to have any concern about myself or my staff any more than there is any reason to have concern about law enforcement in that regard. We're officers of the court and we're professionals. I'm willing to talk to them about it, though, Judge.
Okay, thank you. We have D006, motion to allow confidential defense experts to be present for scientific testing. I'm not sure if you had a chance to look at that. If you have, we can go ahead.
We have, Judge, and I did file a response. The court received a response. Which I think that's maybe a hearing issue, a longer hearing. Some of the agencies that do the scientific testing don't even allow law enforcement members to be present during the testing. I know there are testing being done by Colorado Bureau of Investigations, possibly some other federal agencies. You know, they have rules that we would like to get and provide to the court and defense counsel prior to the court ruling on this motion, and also the Metro Crime Lab for CSPD.
I have no objection to receiving that information and setting a hearing on that issue, Your Honor.
We go ahead and set a hearing on that issue with the caveat that if any of the testing is going to have any destructive kind of testing, that in fact, none of that should be done between now and when we have a hearing. Obviously, if there's destructive testing, whatever's going to be done, defense counsel should be notified of that and should have an expert there who can be present.
Yes, sir.
And frankly, if there's, we'd like to be notified if there's any testing that's going to be done before that hearing, because that would be the purpose of the hearing, is my understanding, is to determine whether we had a right to have an expert present or not.
Do you know who this lawyer is? He's the lawyer for the Batman shooter that drugged them all up, and that's what they want to do to me.
I assume, or is there going to be testing between now and the next hearing?
Okay, just a moment.
If there is anticipated, Judge, I would just ask to be notified so that we could lodge some kind of objection if we saw fit. And certainly if it was destructive testing, as the court says.
Judge, if we could set something within 2 weeks, I don't think anything's going to happen before then, and have that hearing.
Okay. I believe D7 we've dealt with. That's the media coverage issue. D8 we've dealt with. That's for today's hearing. And D9, I believe we're dealing with, or dealt with. I'll get that order out today. D10, I have already signed. That was the stipulation in regard to the arrest warrant and affidavits that go attached to that. D11, I don't believe I have dealt with. That's the defense request to have the pleadings removed from the website. Colonel?
Yes, Judge, we're going to just rest on our pleading, generally speaking, with regard to this. We understand that the media and the public have a qualified First Amendment right to know what's going on and an interest in cases of this nature and this magnitude. However, that right can be fulfilled by the media accessing the pleadings in this case via the court file, the same way as they have always done. By posting the pleadings on the court's website and making them so readily available to the general public, it creates problems. They're microanalyzed and misread, and there's a potential for tainting the jury pool, and there's a potential for skewing the proceedings. So we would object to having the pleadings in this case just posted on the court's website. If there's a specific pleading that either of the parties or the media wants posted for some specific reason, that it's more important, or that it's more that there can't be access through normal channels to that, then we think that they should file a pleading, and we can address that in court to see whether they should be posted. We don't think that the presumption should be that everything is posted, but that nothing is posted. And if,
Just what you want posted, right?
if there are things that people want posted, they can file pleadings and we can address it in court.
District Attorney's position.
We'd leave it to the discretion of the court. I assume state judicial's been through cases like this, and it's probably a convenience thing rather than all the requests, but we leave it up to the court. Certainly if the parties feel there's something more sensitive, they have the ability to ask to have it sealed amongst the parties and then have a hearing on that, but we leave it to your discretion.
Your Honor, may I be heard on behalf of the news media?
Sure.
Once again, Steve Zansberg. I'm here formally on behalf of the Gazette newspaper, the Associated Press, and a large and growing consortium of national news media encompassing ABC, CBS, NBC, New York Times, Washington Post, too numerous to mention, just all of the national, not all of, but the significant members of the news media. And I'd like to say first that with respect to the public's ability to access the pleadings in this case, there have been numerous pleadings that have already been referenced by number at this proceeding and acted upon by the court, to which the public has had no access whatsoever. So in contrast to Mr. King's representation that there's too much information, from my client's perspective, as members of the public, they have no greater standing, no lesser standing than any other member of the public. There hasn't yet been sufficient information about what's gone on in this court proceeding to date. I recognize and appreciate that this proceeding is extremely early, in the very early stages, and from our mutual experience as well as the State Court Administrator's Office in a 3-year People versus James Holmes trial proceeding, I realize there's a long road ahead. But that proceeding does teach us that the clerks of this court would be inundated with requests from my clients and the general public for access to pleadings that are presumptively open to the public under the First Amendment, absent a showing of compelling interest, the highest standard, narrowly tailored, least restrictive means, redaction necessary, the case law with which I'm sure Your Honor is intimately familiar. The presumption is that the courts of this nation, of this state, and its court records are open to the public. That is the presumption that must be overcome by any party to this proceeding who wishes to keep the public from seeing such records. As we've learned, as we've seen in the Aurora Theater shooting case and in other high-profile cases, the State Court Administrator's Office works diligently with Your Honor's chambers and the clerks of the court to provide the public with as speedy access to the redacted records. They are to be redacted before being publicly available, either on the website or through the court's office. And that there hasn't been any issue, there was no issue raised from any prejudice in any of the prior cases as a result of information being posted on any court website. We would urge the court to maintain providing ready access to the public for records of this court, and to allow the press to be heard. If I could go back to the motion that's now been heard and decided upon by the judge, Your Honor, we will look at the gag order, but it does affect the news media. We learned in the Aurora shooting case that governmental entities who are not subject to the court's order, they are not, which would include the coroner's office, other than being added now, but the city of Aurora and ambulance corps and the University of Colorado at Boulder, the Anschutz Medical Campus, all refused to speak to the press after an order identical. I haven't seen it. We haven't seen D9. We haven't seen D1, the orders that my clients are affected by. It's difficult to argue in response to even D11, which I'm presently arguing in response to, without having seen it. I don't know what the basis for the request is, the scope of the request, other than to remove the entire pleadings from the court's website. And I would urge that the public and the press and their counsel be given access to the pleadings of this court so that we can have meaningful discussion, that the public can understand what goes on here.
No matter what item you can have access to the pleadings. The question being whether you're going to have the pleadings and have to come to the courthouse to get it, or whether it's on the website. So we should be clear. You're going to have access. The question is, what kind of access?
Your Honor, a reporter for the Gazette appeared in the clerk's office yesterday and asked to see the proposed gag order attached to D1 and the amended gag order, D9, and was denied access to those records.
Denied access based upon my instructions, because I don't want a number of proposed orders or orders out there to cause confusion. In regard to each individual motion, I just want the final order out there, because I don't want any confusion.
Understood, but again, it is difficult for myself and any other counsel on behalf of any members of the press or the public to meaningfully respond to pleadings that we have not been given access to. Thank you, Your
You'll
Honor.
never know what I saw in that clinic, the atrocities. That's what they want to seal, the babies.
In regard to D11, the court is going to deny D11. The court is going to order that the website will continue. The court needs to balance, I need to balance a number of interests, one being the public's right to know. I also need to balance the defendant's constitutional rights as well as rights in regard to the Victims' Rights Act. And I will be looking at motions, I will be doing orders, and some of them may have to be redacted, but the website will in fact stay up. We have, I believe, D12, which is the motion to preserve videotape footage.
Judge, we just filed those yesterday, both D12 and D13 was in response to the Gazette's expanded media coverage request. And we have served now this morning a copy of D12 upon the county attorney, but we haven't heard whether they want an opportunity to respond to that, what their position is. So I understand that this may be something that needs to be dealt with. Our concern is that this videotape not be destroyed. And so that's our concern. What happens with it down the road can be determined and litigated, but we just want an order that they are to preserve the videotape that they're making at this point.
District Attorney.
Your Honor, I think, well, and I don't know how broad they're looking. Currently, yes, the videotape currently, their order's out and it is being preserved. At some point, I believe the defendant may be moved into a more general housing, which has sort of a general day room that has some general cameras there. Those are very difficult to preserve for them and very costly, and I know they want to have a hearing on that general, and I don't know if you're looking to also preserve those. Those are much more difficult, much more costly, and I know the county attorney wants some input on that issue. What's going on currently, we have no objection to the order for preservation because that's exactly what should be happening. You understand what I'm asking there? And I know currently he's not in general housing. If he goes to general housing, those tapes are actually reused or written over every 30 days. It's not an issue now, but it can be in the future. And that one I know they want to. I didn't know if Lisa Kirkman was. I thought she might be here for the county, but I don't think she's here.
Okay.
Judge, that satisfies me. If there's no objection, and the court will enter an order that the Sheriff's Department is to preserve the video that they're making now, that satisfies me. If we get to the point where there's a movement and it's a different situation, we can raise that with the court and have it address the issue at that point.
The court would grant D12 with the understanding that it's where he's being housed right now.
I'm housed with no toilet, no water. Contact Amnesty International, have them contact me, please.
And certainly, if the county wants to be heard on it, we can set it for his. Perhaps we can set it for the same 2-week period down the road, and we're going to talk about the destruction.
And what I'll do then is we'll make sure the sheriff's office knows to preserve the videos that they currently have.
Okay.
I'm not going to tell them to preserve the 30-day videos if he's moved to general housing. I'm putting them on notice. They do get redone in every 30 days, and then defense can decide whether they want to file a motion regarding those, and then the county can have an opportunity to be heard on that.
That's fair enough.
Okay. I believe that takes care of defendant's motions at this point that we've dealt with. Are there any people's motions that I have not dealt with?
Judge, we filed P005 this morning prior to coming over to court. It is a motion for discovery information and what defense is to do with the discovery as it comes to them. don't know if the court has a copy of that.
I do, I have that in front of me. I'm not sure if the defense counsel has that or has had an opportunity to look.
Judge, we've had a chance to review that, and I don't have a specific objection to that motion at this point in time. We understand the reason for that. However, if there should come, if an issue should arise where we do need to ask a question about a specific individual, and I don't foresee that at this point, but it may happen. We'd just ask leave to bring that issue before the court and ask for some kind of an exemption in that specific circumstance. And again, I don't foresee that circumstance taking place, but I don't want to completely tie my hands, if you understand.
Either court will grant P5 with a comment.
Thank you, Judge.
I believe that takes care of the motions.
I do have one additional regarding to some of the stipulations I think that are coming, just to put the court on notice.
Okay.
Judge, there was a substantial amount of police gear at the scene, and it was left at the scene. We have investigators looking at that gear and determining if it's evidentiary purposes. We have 2 sets of investigators, and what we've told the defense is that anything that's evidentiary, we're going to put in evidence. Anything that's not evidentiary has either impacts or evidence on it, and we're going to seek to release back to either El Paso County Sheriff's Office or the Colorado Springs Police Department. And I understand that they're in agreement with that. I just want to tell the court it's coming that way, coming your way, and we'll try to get that filed very quickly.
Judge, yeah, that's the case. The detective from the Colorado Springs Police Department was kind enough to discuss the procedure with us. We think it's reasonable and for the safety of the community makes a lot of sense. We just asked when that procedure is over if we could receive a list of the items so that we're clear what they are. That's all.
Yes, sir. And just so the record's clear, I am granting P3, which is the stipulation to release some items, and also approving the stipulation to release the police vehicles, which is P4.
Thank you, Judge.
Okay. I think at this point we'll...
Well, Judge, I do want to put a disclosure on the record. I'm assuming the parties here are aware of the fact. Our office prosecuted several cases against a gentleman by the name of Bruce Nazzolino. The primary charge was first-degree murder and attempted murder, which resulted in a trial last year in him being convicted of first-degree murder and several counts of attempted murder. You were actually a victim in that case, a named victim, and he was convicted of attempted murder on yourself. I'm assuming the parties here are aware of that because the same government agency that represents the defendant here represented Mr. Nazzolino for many months. The eventual trial was done by ADC. You are a listed victim. That case is on appeal. You still have the victim's rights under the Victims' Rights Amendment. I will note that both of my co-counsel here worked at various stages of the Nazzolino case. Donna Billick in particular was one of the 2 trial attorneys on that case and would have worked with you as a victim on the case. I'll also note for the record that all 3 counsel at the table were up at the scene prior to the arrest of the defendant here. So all 3 counsel were already involved before we knew where this was being assigned to the courthouse. But I wanted to put that disclosure on the record for all parties to be aware of that so it doesn't come up or there aren't concerns in future proceedings.
Okay.
Anything else on that?
So noted. Anything else?
I have nothing with regard to that, Your Honor, but I do have one other issue, and that is we have, as I said, had a chance to talk to the detective from the Colorado Springs Department, and we have made requests of the District Attorney's Office that we receive the discovery as quickly as we possibly can in this case. Judge, we cannot begin to make a determination about the nature or the depth of Mr. Deere's mental illness until we receive full disclosure from the District Attorney's Office. We're specifically concerned with the videotapes from the crime scene and the videotapes of any interrogation or audio tapes of any interrogation which took place after Mr. Deere's arrest. It's vital that we see that information as soon as we possibly can. We have serious concerns about competency in this case.
and we are engaging in an investigation to the issues surrounding competency, and it is vital in order for us to do that we get the discovery of those items that I've just mentioned. And I understand in a case of this magnitude, there's a lot of material, and it's a lot of work for law enforcement and the district attorney's office to get to us. If we could somehow get that important information to us first, it would expedite the process and would move the process forward, and we would not
Do you have
have
the
to be
information in the
asking
newspaper?
for any delays.
Your Honor, we do have the audio taped interview DVD. We just received it from the police department. We're going to make arrangements to try to get that to defense tomorrow. As far as the rest of the evidence, there's a ton. There's a lot of information. As the court saw, there's 400 witnesses potentially on our witness list attached to or filed with our complaint information. We will get that information to the defense attorney just as quickly as we can. As I said, the interview of the defendant will probably come to the defense tomorrow.
Okay. That being said, the next issue or the next item we need to decide is, do we want to set are you requesting a preliminary hearing at this time, or
No, Your Honor, I could not represent that we're competent to set a preliminary hearing at this point.
how do you wish to proceed?
I think we should set it for a status hearing on the issue of competency, and I think we should set it for a hearing on the issue that we talked about before in about 2 weeks, 2 or 3 weeks,
Okay.
would be my
Is the
request.
defense intending to ask for a preliminary hearing, or are they waiving the right to a preliminary hearing?
I don't believe he's waiving the right to preliminary. I didn't hear that.
I'm not waiving the right to anything. I'm just not requesting one at this time.
Now, you have the 35-day rule. Are you waiving the right to have a preliminary hearing within 35 days from today?
Judge, we would like to do that, but honestly, we don't know if we're competent to do that today. We would have to review that with Mr. Deere and make that determination. So if we can set it in 2 to 3 weeks, I could be able to make that representation to the court.
I would request a preliminary hearing within 35 days. I believe under the rule that either the prosecution or defense can request that. So we are requesting that. And specifically on the competency issue, it does say in 16-8.5-102 that a preliminary hearing can be set even if the court found the defendant competent today. That a preliminary hearing can still be set and held in absence of the defendant. So we would ask that we have a preliminary hearing.
Well, I understand that, but that be a meaningful preliminary hearing. If we set it within 35 days and don't have complete discovery, understanding it's a preliminary hearing, understanding that you can go to preliminary sometimes without complete discovery. This isn't a theft case. I think defense counsel is entitled to have all the discovery before they prepare for a preliminary hearing.
Although I haven't heard them object to my request for one within 35 days, I haven't heard them actually ask for one at all. So I'm making a request for one for 35 days. I don't know what their position is on that.
We're about to find out, I'm sure.
Judge, my position is that we object. I think it's rather ironic that the prosecution has not turned over one piece of discovery to us yet, not one page of paper, and yet they want to set a preliminary hearing within 30
They want
days?
the truth out.
It's unreasonable, Judge.
This is unheard of, that the prosecution is trying to help get the truth out, and you're trying to silence the truth. You're trying to make me go, you want to make...
I think the problem is obvious, Judge.
I'm denying the district attorney's request for a preliminary hearing at this time. It needs to be a meaningful preliminary hearing, and quite frankly, if we don't have discovery to defense counsel, I don't see how that could be a meaningful preliminary hearing. I don't have any problem with setting that over for 2 weeks to look at the competency issues and determine where we want to go from there. Any objections to that, Mr. Chair?
Other than my request, obviously already put on the record, we do not have an objection otherwise, you guys.
Okay. Is there any day of the week that's better for you all? I would prefer, quite frankly, Wednesdays because it's less busy in the courthouse. So it makes it easier just for us, but I can accommodate any other day as well.
Whatever's convenient for the court, from my perspective.
December the week of December the 28th or the week of December 21st, whatever.
The week of the 21st, Your Honor, if we could.
So it'll be December the 23rd.
Can we just check real quick with our...
Sure.
If that's not okay, we can accept the 28th as well.
Or actually, your 30th would be the Wednesday.
That would be fine as well.
The 23rd is fine with us. It's fine,
Which one?
23rd.
All right. Well, we'll continue the matter for further proceedings to December 23rd. I assume 1:30 is the best as well?
That's fine, Your Honor, thank you.
Okay. That being said, do you wish to talk to Planned Parenthood and then come back in, or do we need to do anything with that on the record?
That's fine.
Come back in.
Okay. Anything else?
Not from us, Judge.
Not at this time.
Can I have counsel put your bench one more time?
Nobody will ever know the amount of blood I saw inside that place.
All right, we're going to take a brief recess. I'm going to ask that you can go ahead and talk to who you need to talk to. While you're doing that, if you'll go ahead and take the defendant out and then bring him back, we'll let you know when they're ready. All right, anything else?
All rise.
It's my understanding that we do not need to put anything else on the record, so we're set to go December 23rd at 1:30.
That is correct, Judge. We met, and I think we're in agreement as to any protection orders or any issues with the scene view.
That's correct, Judge.
The concern I have, as I was thinking about this, it's the defendant's right to have a preliminary hearing, and he may have to waive the preliminary, or waive the 35 days. Mr. Deere, you have the right to have a preliminary hearing within 35 days from the filing of the charges, or you can waive your right to have that hearing within 35 days.
Oh, I want the right. I want the truth to come out. There's a lot more to this than me to go silently into the grave. There's a lot of things that they don't want to be known. Planned Parenthood and my lawyer are in cahoots to shut me up because they don't want the truth out.
Just listen to me for a moment, okay? You, in fact, have a right to have a preliminary hearing within 35 days from today. Your attorney is not requesting a preliminary hearing within that 35 days. Is that okay with you?
No.
Do you wish to have a preliminary?
Yes.
Within 35 days?
I want it, everything as soon as possible.
All right, counsel.
Judge, my preference is to keep it set the way we are. I cannot represent that Mr. Deere is competent to make this decision as he sits here today. I simply cannot do that until I'm provided with some more information and we complete some more investigation. So I am not requesting a preliminary hearing today.
Court, with the understanding that Mr. Deere wants it within 35 days, I also understand the defense counsel's indication he needs discovery. He cannot tell me how he wants to proceed in regard to competency. The court is going to continue it for the 2-week period or for the proceeding state.
And I'm not going to agree to their mental health evaluations where they want to take me and put me under psychotropic drugs so that I can't talk like the Batman guy.
Finished? Okay. I'll see you on December 23rd at 1:30.